Let us welcome your speaker today, Mr. Ken Cuccinelli.
There are two sons in there, but it's funny, if you throw the blessing part in, it becomes a little more dubious. But it is good to be with you all this morning. It's always a pleasure to be with the Blackwells, and I appreciate the invitation to return to the Leadership Institute, which is doing so much good work. I'm going to talk about three things. One of them is I'm going to publicly unveil my next lawsuit concept. Now all I need are plaintiffs. And then, and you all know some prospects, but, and then I'm going to talk to you about that NSA lawsuit, and I'm going to relate that to the fact that we did win the youngest segment of voters in 2013. It isn't directly related, but subject matter-wise, it is. And I think it's important for us, of all the different groups that we focus on from a conservative perspective, and where better to say this than the Leadership Institute, none is more important than younger voters. They truly are the future, and if we want to win the future, we've got to start right there. And they've got to be with us. It isn't enough to win them over. They've got to be part of our effort going forward. So, the new item. You are all painfully familiar with the President's various abuses of executive authority. There's literally too many to catalog or to discuss. I'm going to focus on Obamacare for two main reasons. One, I like focusing on Obamacare, and for a variety of personal historical reasons. I believe it is the greatest invasion of liberty through legislation in my lifetime. And that's the important way to think about it. Of course, it's destroying the healthcare system, but that's actually secondary to its destruction of liberty. We can recover some part of our economy being, frankly, slowed down. I don't want to say destroyed, but the damage being done to healthcare itself is pretty substantial right now. It's harder to recover from the sacrifice of liberty. And I'll zero in on one example of the abuse here. Now, it's odd for us, first of all, let's caveat this. It is strange in some ways to have this conversation, because what I'm going to be talking about is enforcing Obamacare. But among President Lincoln's many useful quotes is one in which he noted that the best way to get rid of a bad law is to enforce it vigorously. And this president is so proud of his signature achievement that at every new deadline they make some new exception or roll it back or just don't implement it. For instance, the employer mandate, which was supposed to go into effect on January 1st. The challenge thus far has been finding harmed plaintiffs who were willing to proceed against the president. And which is kind of amazing given how many different times and ways the president is violating the law using his executive authority. Just to put it for the non-lawyers of you here in sort of theoretical terms, focusing on Obamacare, if you were on the winning side, of course, by definition, you were a Democrat in that vote, because no Republicans voted for it. But it was close. In the House, it was a 6-vote margin. And in the Senate, they didn't have a vote to spare for the cloture vote, 60-40. And so if you and 5 other of your fellow hypothetical Democrats, really you only need 2 other hypothetical Democrats, had voted the other way, the bill would have failed on a tie vote. So if 3 of those people who voted to pass the law, and we're focusing on Democrats right now, let's amusingly consider, say, Jim Moran suing the president, just for fun. And his case would be, his claim would be, with respect to the employer mandate, I voted for this, it passed, the president signed it, it became a law, it even withstood a constitutional challenge, and now the president has amended the legislation. He doesn't have the ability to amend the legislation. Congress does. Interestingly, the president has even threatened to veto a congressional bill delivered to him that does exactly what he's doing through the use of unilateral executive authority. It is his intention to invade the prerogatives of Congress, to sweep into the executive branch legislative power. This is a violation of the separation of powers. Now, let's go back to our hypothetical plaintiff, Mr. Moran. He will always be hypothetical, particularly in this scenario. So who else might bring this suit? As we all know, in 2010, as a result of the votes for Obamacare, in large part, scores of Democrats lost to Republicans. The exact numbers escape me, but it was in the realm of 80. Or retirements happened that Republicans took those seats. Now, interestingly, it is very difficult to obtain what's called legislative standing. And what I just described to you was a winning congressman who voted for something, got it, and then the president unilaterally blocked the implementation of what he had voted for, which is the nullification of his vote, to use the phrase from the Supreme Court. And that gives him standing. He is injured. You have to have an injury to have a lawsuit. And he is injured as a congressman in his congressional representative capacity, not as an individual American, but because his congressional vote has been made ineffective by the president rewriting the law that he voted for. So if he and two others, maybe Dennis Kucinich and Jerry Connolly, was Connolly in then? It's too bad. But so there's our three. If they'd voted the other way, it would have been a tie, and the bill would have failed. So if the three of them were to come forward as plaintiffs, because their votes have been now nullified by the president's action, they could survive a standing challenge. Now, what I've been looking at for some time now, and I'm now convinced this can be done, is that Robert Hurt, Scott Ridgell, though not Morgan Griffith, because Rick Boucher voted against Obamacare, and let's pick another, McKinley in West Virginia, who took Alan Mulholland's seat. They all now occupy seats that voted for Obamacare. Obviously, none of them did, but congressional representatives hold those seats in the form of a trustee, which means you succeed to everything your predecessors in that seat have done, which also means that Robert Hurt, Scott Ridgell, and David McKinley are all the plaintiffs I need, because their district voted for Obamacare, and that vote has been nullified by unilateral executive action by the president. And this is all based on Supreme Court cases. Now, I will grant you there hasn't been one that's gone this way, but the Supreme Court has spoken to it. You know, one of these things where they write, well, if the bill gets enacted, and in parentheses, or not enacted, and it isn't implemented, and then in parentheses, or it is implemented. So they've done both sides of the coin here. And legislative standing began, really the modern version of it, with a case called Coleman v. Miller in 1939. And in Coleman v. Miller, like Virginia, Kansas has a 40-member Senate, state Senate. They had a 20-20 tie on a constitutional amendment, U.S. constitutional amendment. So it was a ratification vote. And the lieutenant governor broke the tie in favor of ratification. And the 20 senators who voted no sued, saying the lieutenant governor doesn't get to vote on ratification in Kansas. And so our votes, which would have carried the day, were nullified. They were made ineffective. And the Supreme Court said that gives them legislative standing, this rather unique category of injury, because they weren't injured as Kansans. They were injured as members of a legislative body, and that's it. That's their injury. It is a unique injury that other people don't suffer, and so the Supreme Court let them go forward. Couple elements. They had to have otherwise prevailed. That's why I'm using the 3 congressmen, because if you flip 3 votes, Obamacare fails. That's important. And, again, it had to be decisive. So you got to have the right number, and it had to change the outcome if the allegations are correct. And this isn't like some district court somewhere. This is putting together Supreme Court jurisprudence on the subject, and it would be novel, but so what? One of the great things about being a right-winger and suing the president, there are many of them, but it's using their own tactic against them. It's just delicious. And of course, it's part of what the courts are for. It's amazing when we sued on the Obamacare case, activists, nullification, proving that journalists have no idea what they're talking about. Like anybody in this room needed that proof, but nonetheless. What we were doing was working within the system. Nullification is going outside the system. The federal courts are supposed to be the arbiter, the referee of these contests of constitutional power. And that's what we were carrying forward in a genuine act of federalism in action in the healthcare case. And that kind of opportunity exists here. If we can get 3 class of 2010 Republicans, and I think Morgan Griffith is the only exception because he beat a guy who voted against Obamacare. For those of you who don't know, Morgan represents Southwest Virginia, and the killer for his opponent was that he helped get Shepherd cap and trade out in coal country. Thank you very little. And while we've run good candidates against him in the past, no one had broke 40% that I remember, and Morgan beat him on that one vote. And but all the others in that class, I believe, took the seats of Democrats who had voted for Obamacare. So there are 80 or so potential plaintiffs here that would fulfill my legal need as a lawyer. It's great to be a lawyer. You need clients. So that is, you all are now the first publicly to hear my legal theory, which I spent some time developing and have bounced off others. And so far, no one has really poked a hole in it, except that it's hard. It just is. The courts they're still resistant to legislative standing, but and they seem to shy away, strangely enough, from undoing the efforts of the president, even when they're rather nakedly illegal. But you don't win any fights, you don't get in. And I've seen over the years in elected office, 12 years, more people who were just unwilling to fight. And it was always astonishing to me. I sort of had the thought, well, why are you here? Especially when I started campaigning statewide, all of these representatives, senators or delegates who were just mice in Richmond, boy, you got back in their district and they were lions. It was amazing. I thought they all had twin brothers. Nonetheless, a willingness to lose is important. Nothing ventured, nothing gained. And we have much to gain in these kinds of contests. And I would say regain. It isn't just pushing back this president. That can have some political appeal. The rule of law is at stake right now in this country. Liberty itself is under assault from the most dangerous place in our society from the founders' perspective, and that is government. It is the greatest lawbreaker of them all. And we need to undertake efforts to hold it in check. Elections are the ultimate check, but there are other tools, and I am undertaking to exercise them as best I can. We filed the NSA case. It didn't occur to me till later, but 1 month to the day after I had stopped being Attorney General. And one of my friends said, well, what took you so long? And I said, well, give me a little time off. But in that case, we are suing, and this week we filed our motion for class certification. So if there's anyone here who doesn't use a phone, I will not represent you. But if you use a phone and the class is certified, as we expect, because we filed a class action on this, I'll be your lawyer. So, and the rate is good for you. The only thing we focused on is the Fourth Amendment violation. And it's interesting, when privacy means privacy, I can agree with the ACLU. When it doesn't mean the ability to take another human being's life, and it actually means privacy, like Noah Webster would call privacy, it's amazing the breadth of our support conceptually, including, most critically, among younger voters. Far and away, the most idealistic voters in the electorate. And also, I'll say subject, and I mean that in a good way, to appeal on the basis of being for freedom. Which is why Ron Paul, the kind of old, it's not like he was smooth, and I like Ron Paul, but smooth wasn't his appeal. It was here. It was free-based freedom. And he was kicking everybody's tail among young voters. And we can too. There are lessons to be learned, and it is why I won under 25s. Because I do have a track record in that area. Wasn't enough, but it's important. And why that happened is important. And things like the NSA, not the case, but the question at issue. And we're suing because our own federal government is sweeping up 5 years of all of our phone data, pretty much everything about your phone and your phone calls except the words you're speaking to other people. Which, the other side likes to say, well, it's no big deal, it's just a bunch of numbers. A couple of Stanford folks just finished a very simple empirical study. They're still doing it with just over 500 people who signed up. They all had Android phones and they got the app, of course, right? And they allowed themselves to essentially be surveilled in the manner that the NSA is gathering in their data. And just looking at the phone numbers they were calling, when they were calling, how long they were calling, and by the way, they're getting rough location information on you as well. That isn't getting discussed much, but they are getting it. And it's intentional. It's not accidental. And with just over 500 of those folks for just 3 months, they could infer religious belief, political affiliation, gun ownership, medical conditions, to an astonishing degree of specificity just based on phone calls. And they checked the religious affiliation against those who had listed their religious affiliation on Facebook, because that was a connector they required so they could analyze the accuracy of their inferences. And the religious inferences were right about 3/4 of the time, like down to the denomination, not just Christian, but what flavor. And that's just 500 people, not 250 million over 5 years, not just 3 months. And interestingly, if you think about one person in their database who they're quick to tell you, but we don't have their name. We just have their phone number. Which takes an act of willful idiocy to not connect. And so they do. Nonetheless, the more you learn, let's just take this room full of folks. The more data I can gather on you and your phone calls, well, I gotta change my pronoun, that they can gather on you and your phone calls, the better they can understand my data. Because of the interaction between us, and that doesn't just mean directly, it can mean via several hops. Calling RNC, the news hits 9 p.m., we're all calling RNC, what the hell are you doing today? They can kind of figure some things out. A phone call at 2 in the afternoon for 30 minutes can mean something very different than a phone call at 2 in the morning for 30 minutes. And the more they learn about your data, the more they can understand my data. And this presents a very novel legal problem. And the legal problem is that we defend individuals in our legal system. This class action approach is very rare, especially for Fourth Amendment, which is very case specific. So let's say no one else in the country challenged this undertaking, and yet without ever touching my data, they're learning more about me by looking at yours. So how do I go into court to stop that? There's no existing jurisprudence on this at all. None. Now, the class action approach gets at part of the problem. It doesn't get at the problem I just described to you. And at a societal level, we're going to have to figure that out. Because we can learn too much about each other, we can know too much about each other, and government can know, most importantly, that's who we're defending against, based on what we learn from everybody else. And so normally I can't file a claim to block the government from getting, say, Morton's information. I have no basis to do that. Morton has to do that.
I'm ready.
I'm in the right room for this, for sure. But nonetheless, in the digital age, with big data in particular is what's bringing this on, I have an interest that I never had before in that relationship and how it's conducted, because it affects my relationship with my own government. And I don't stand here before you with an answer to that question. I would just raise for your brain ticklish time that that's an interesting and dicey one. That there are Supreme Court cases, the Jones case 2 years ago, where the justices, all but 5 of them, all but said, you can now conduct surveillance without ever seeing someone or trespassing on their property or their vehicle or wiretapping them. You can learn more about them from their data than you can a lot of their conversations. And by the way, I can process 250 million people's all standardized telephone data a whole lot easier than I can process voice telephone calls. Every one of us in this room, if we had a paragraph, would say it differently. And the processing power needed to attack that problem alone is logarithmically more than what they need to deal with the telephone metadata they're sweeping up. And they're doing it without a warrant. They don't suspect you or me. Well, they suspect us of some things, but they don't have any formal basis for suspicion of any of us when they gather our data. Fourth Amendment says, got a probable cause, get a warrant. Judge decides that. Well, right now, some guys at the NSA are deciding that. Once they get approval from the FISA court to sweep all this up, they're searching it without further court intervention. They have rules and so forth. I saw a great blog post on this subject not long ago, and it was from a guy who, in very short order, I actually saved it because I may use it in court. He said, look, hero, traitor, or whatever you think Edward Snowden is, he proved 2 things beyond all doubt. 1, the containment of the NSA's data is only as good as the employees who have access to it. 2, not all the employees are good. So they can talk about protecting it and minimization procedures and all they want. The only way to avoid the abuse of power or information is not to allow it to be accumulated. Period. It's the only way. And here they're doing it in a manner that really starts to smack of the colonial period writs of assistance, general warrants, where the new king would get coronated and sign one piece of paper for his entire reign that would give his officers the ability to just walk in your house on a fishing expedition and just poke around and look for what they wanted to look for. This gets awfully close to that. Very, very close. It's interesting, on December 15th of 2005, then Senator Obama took to the floor of the Senate decrying this particular part of the Patriot Act that they're using, which, by the way, the author, Jim Sensenbrenner, said they're doing what? We never said they could do that. That's the guy who wrote the Patriot Act. So in 2005, Senator Obama was decrying how awful this is, and his final clause was, this is just wrong. They're going to get your phone data. You're not going to have an appeal. You're not going to know. This is just wrong. Then he became president, and he expanded it, which is, again, a good example on a bipartisan basis of why you don't let them accumulate this power. And them is not Democrats. It's people in government. This is bipartisan. It is bipartisan. We are waiting for the government's motion to dismiss. That'll probably come on May 1st. Very appropriate May Day. But we're preparing for that. There are several cases running around the country, and we'll see where this ends up. It may be that it has to be resolved by legislation if the courts do not find that this is a violation of our protected Fourth Amendment privacy. I hope both will happen, and I'm somewhat confident that it will. Let me segue back into the youth vote just again. This is a freedom issue. We have Democrats and Republicans who oppose the notion of stopping this activity. And I'm sure there are people in this room who are in that position. This is not one that breaks down along Republican-Democrat lines. But if you were to analyze the response of Americans by age, you would start to see some patterns. And the most striking and consistent element of that pattern would be that young people oppose this vehemently. Vehemently. And it is back to that freedom focus that they have that I commented on earlier. And if you want to just step back from what's right and wrong and what's protective of or abusive of our Constitution and look at it from a vote analysis standpoint, this kind of defense of freedom attracts young voters passionately. I mean, not they'll just come vote for you. This fires them up. A distinction Morton makes quite frequently and the Leadership Institute teaches. There's a difference between differentiating and motivating. Both are important, but that's how important freedom-focused issues like this one are to younger voters. In my governor's race, we made a point of having a drone policy. You can probably kind of guess what it looked like. But it's not that it was going to impact a lot of people's lives, but it was important to some people, to put it in Stephen Covey terms. You know, he likes to talk about relationships. Well, if it's a 2 to you and it's a 9 to your wife, do it. You know? Suck it up. And this is one of those things that for a lot of people is a 1 or a 2, but for the under 30 set, it spikes to 8, 9, or 10. And we should be looking for those opportunities, because that's what they are. And we don't have to change anything we believe. We have to focus it in a meaningful way on what they care about. I would never advocate sacrificing principles. This is applying principles. And the results can be very fruitful. There are a variety of issues in this sphere that cut across party lines. They tend to be, if you were to put them in one plot, they tend to be more libertarian. We have a lot of elements of what we call conservative today, because really a conservative today is a Madisonian liberal in most respects. The words got all jumbled up over the course of American political history. And the founders are by and large libertarian. They really weren't dealing with social issues at the time, so that sort of third piece wasn't there to break people down much. And we're the heirs to that legacy. And I believe we have a moral obligation to carry it forward vigorously. But I will tell you that politically there are rewards if we do. They're long-term. They're not just long-term. They're also short-term. But they're real. They're very real. You know, in a race where I, the Republican candidate for governor, lost, not by a lot, 2.5 points, but normally if in a traditional race, if you have a Republican losing, you'd break down the kind of demographics, and you wouldn't expect to see a Republican winning the youth vote while overall losing the race. Again, it was close, but and one of the factors in state races is the proportion of the electorate that is younger drops from, I'm using very rough numbers, from about 20% under 30 in the presidential races to about 10% in ours. So you get a much more concentrated group of young voters. And by concentrated, I mean to come out at all relative to their peers, they have to be a lot more focused on this. So those opportunities are there for us to seize. We shouldn't shy away from it. I'm not advocating giving up the security of our country, of course, but more than that, I'm advocating not giving up the cherishing of the Bill of Rights and our Constitution, which people from both parties are more than happy to trample and are less bothered to even try to understand. We have a huge opportunity with younger voters right before us in the fundamental document that governs government, and that's our Constitution. If we're willing to regularly, consistently stand up and defend it. And it's worth remembering consistently, let's say some Republican wins in 2016, we need to keep doing it in 17, 18, 19, 20 if we want to be the consistent garners of this part of the vote. So that is it can be done. We've proved it can be done. I think that's a hopeful message for us from a political standpoint. It's also a good motivator to stick with those principles. And there are lots of things that try to tug us away from those principles out in the real world. It is important to realize there are real world benefits to sticking with those principles. And the future is one of them in the form of our young voters. So, Morton, I appreciate the chance to be with you. You guys are in charge of the clock, but I'm happy to take questions if you want.